My name is Janina Dill. I'm a professor of global security. Welcome to my exp. There are three bodies of international law that are relevant to how wars must be waged. General international law prohibits that states start a war in most circumstances, so there's a general prohibition on the use of force, which is enshrined in the Charter of the United Nations. There are some limited exceptions, like self-defense, but generally we have a law that is sometimes called jus ad bellum, which prohibits the onset of war. Then we have a body of law that prescribes how wars must unfold. It's mostly called International Humanitarian Law or the laws of war. Sometimes it's called jus in bello. And it prescribes certain conduct on the battlefield and it puts certain things off limits. Some violations of international humanitarian law are criminalized. So it's possible that if an individual violates international humanitarian law in a certain way, that they are later held to account by a criminal court or tribunal. And that's regulated in international criminal law. Of course, law is only one factor that shapes how the wars that we witness day to day unfold. Most of the time, I'm afraid, war follows imperatives of strategy, of politics. There are really strong affective or emotional dynamics on battlefields. And of course, ideally, ethics or morality would also shape how people conduct wars and when wars start. Law is one factor that helps us understand and make sense of the violence and the war we witness in international relations every day. International law isn't enforced in the way domestic law is enforced. The kind of blueprint of legal enforcement that most of us have in our mind is that if you threaten someone with violence or that you use violence against somebody else, for instance, in the United Kingdom, the police would come, a court would then decide whether you broke the law, potentially issue an arrest warrant, and the police would execute this arrest warrant and put you in jail. This isn't quite how it works in the international system. We have courts that can adjudicate and determine when a state breaks law, but these courts don't have jurisdiction over every legal question that might arise in international relations. And these courts, like the International Court of Justice, for instance, when they have jurisdiction and they can determine that a state violated international law, for instance, by going to war illegally or by breaking another rule of international law, they can command that state to cease, they can impose a demand of reparations, but there's no international police force that will then execute that order. So how should international law then be enforced? Well, we think of it as a horizontal system of enforcement, where states are supposed to enforce law vis-à-vis each other, rather than a vertical system where you have a sovereign with a police force that enforces law vis-à-vis the subjects. So generally, when a state is found to have violated international law, other states are called upon to impose sanctions, to seize trade, to protest diplomatically. And there's a rule of international law where states are not allowed to support another state in violating international law, generally speaking. Of course, that system of horizontal enforcement is often disrupted by politics because states may find that they don't have an interest in enforcing a particular international law. We also have a little bit of a vertical enforcement. The UN Security Council is in charge of enforcing the international law that prohibits the use of force. So the Security Council can mandate the use of force in response to an aggression, for instance. But again, the Security Council is made up of states. They vote in line with their interests. So oftentimes, enforcement is disrupted by politics, and it's therefore not entirely reliable, it's uneven. So whether or not a state that breaks international law actually encounters a consequence for that is often a matter of politics and not only a question of whether we can reliably or convincingly demonstrate that they violated international law. When it comes to how states or armed groups must behave themselves on the battlefield, we are looking towards a series of treaties called the Geneva Conventions. And they really have, many provisions that are also customary law, but they are the most important treaties that regulate how wars must unfold, how we must use force against each other, how we must treat detainees. They regulate humanitarian operations and occupation. For the conduct of hostilities, so how two belligerent parties or two parties at war really try to hurt each other, use kinetic force against each other, we look at three principles in particular called the principles of necessity, distinction, and proportionality. Let me start with distinction because in some sense that's the most fundamental principles around which the laws of war are built. The principle of distinction suggests that civilians must never directly or intentionally be attacked, and combatants can always be attacked in war. There's a parallel provision that suggests that civilian objects must never be intentionally or directly attacked, and military objectives, which are objects that have a military purpose, can at all times be attacked or destroyed. That is the principle of distinction. Concretely, it really means that every time a soldier releases their weapon in war, every attack in war must be directed against a target that the attacker knows or at least has reasonable grounds to believe is either a military objective, so an object that is a military objective, or a combatant or fighter. It is never permissible to direct an attack against a person that we know to be a civilian or against a civilian object. That is the principle of distinction. Now, in many attacks that are targeted appropriately, so against a combatant or a military objective, the attacker will be able to foresee that the attack causes some damage to civilian infrastructure or some harm to civilians as a side effect of the attack. That's something militaries tend to call collateral damage. The law calls that incidental civilian harm. Now, that must be minimized as much as possible. That's the principle of necessity. Only the incidental civilian harm that is necessary for the achievement of a military advantage, so that cannot possibly be avoided, is permissible. So parties to a war here, attackers, are called upon to take all feasible precautions to minimize that incidental civilian harm or collateral damage. For instance, through the choice of weapon, the time or the angle of attack. It's also sometimes an option to issue a warning so that civilians can move away from military objectives, which is also a means to reduce the kind of foreseeable collateral damage to that which is really unavoidable or necessary. Now, collateral damage or incidental civilian harm that's necessary, so that really can't be avoided in the course of an attack against a military objective, then also has to be proportionate. The law uses the term not excessive. So it must be not excessive in relation to the anticipated military advantage of an attack. So there's something the attacker tries to achieve with the attack, right? For instance, neutralize a commander or neutralize or destroy some military equipment. The military advantage that is anticipated to arise from that must be weighed against that foreseeable and unavoidable civilian harm. So that's a type of a balancing exercise between civilian harm and military advantage. And it is entirely possible that an attack that is appropriately directed against a combatant or a military objective, and where the attacker has done everything feasible to minimize civilian harm, that attack is still illegal if the foreseeable civilian harm is disproportionate to that anticipated military gain. There are several divergences between what international law permits or doesn't prohibit and what a kind of a moral approach to permissible killing would imply. For instance, international humanitarian law permits us to attack or doesn't prohibit attacks against combatants. And a combatant can simply be someone who was conscripted into the armed forces of their state and was in a sense compelled to legally or as a matter of fact fight for an unjust cause. Now, from a perspective of morality, you would say that someone who had no choice in whether they want to fight, or also someone who fights for a just cause, is actually not morally liable to harming. We wouldn't be allowed to kill someone who acts in self-defense, for instance. Law doesn't make that distinction. From a perspective of law, the soldiers on both sides in the war are equally liable to killing and to harming. And even if they had no choice in fighting, they're still at all times permissible targets of lethal attack. So there's a disjuncture between what is morally permissible and what isn't prohibited by the law. There are quite a few misconceptions about international law as it pertains to war in the public discourse, I'm afraid. I think the most important one is, first of all, highly legalized war is still a moral catastrophe, right? So Law isn't the panacea that will somehow make war acceptable, sanitized, and morally appropriate. War will always be a moral catastrophe, even when it is fully and utterly subjected to law. And yet, law has still an incredibly important role to play in curbing violence and somehow lessening the moral evil that is war. And therefore, we must insist on compliance with law, and we must really work towards better bringing laws in compliance with war. And when we see non-compliance, as we currently do, it doesn't really matter which current war to look at. Russia's war in Ukraine, Israel's war in Gaza, the war in Sudan. These are all massive crises of compliance where most of the time neither side, but definitely in all cases at least one side, really systematically violates international law. And the misconception there often that this is the fault of the law, that if the law were better articulated, clearer, that this would somehow stop. But it isn't most of the time a challenge that stems from law. It is almost entirely a challenge that stems from politics and lack of political courage.